Good morning. This is Kim Drew from the Iowa Department of Education. Here with me are Mary Jackson and Brandy McComber, who are resource managers from Vocational Rehab. We want to welcome you to the WIOA Basics webinar this morning. The chat box is the only place where you are going to be able to ask questions this morning. Because we have so many people online, it doesn't make sense for us to try to do that vocally. So please use that as your option to ask questions as we go throughout the presentation. A caveat before we get started, there are still a lot of questions remaining as to what's going to happen as this legislation is unpacked. The presentation that we're going to give you today is what is current as of today. If and when changes occur, we will get those things out to you. If there are things that we don't have answers to, we will certainly research and include those in the FAQ. We do plan to have a written FAQ posted along with a recorded version of this webinar out after the holidays in case you need to refer back to it or have questions that came up. So with that, we're going to go ahead and get started. The main part of the agenda is to cover the Workforce Innovations Opportunities Act, which is WIOA. We're going to talk about some definitions. We're going to talk about the implementation of pre-employment transition services, or PETS. We are going to talk about intensive services, Section 511, and then we'll close out with the Memorandum of Agreement between the DE and IVRS. The next slide talks about how WIOA aligns with IDEA. On July 22nd, 2014, President Obama signed the Workforce Innovation and Opportunities Act, WIOA, into law. The provisions related to IVRS work in schools creates a continuum of services that aligns with IDEA, but it does not supplant the legal responsibility of the schools. Mandates the schools and IVRS are to jointly develop a system so students achieve competitive, integrated employment and do not work for a CRP at sub-minimum wage. Mary?
Okay, so like Kim said, we're going to start out with some definitions. And again, please keep in mind that we do not have the final regs on a lot of this stuff, and so this is subject to change. But as of right now, we're going to start with these definitions. So it's youth versus student. Youth with a disability is an individual with a disability, regardless if they are in school, who is not younger than 14 years of age and is not older than 24 years of age. Student with a disability is an individual with a disability in school who is not younger than 14 years of age and is not older than 21 years of age, or if the state allows for a higher maximum age, is not older than that maximum age, and is eligible for and receiving special education or related services under Part B of IDEA, or is an individual with a disability for purposes of Section 504. And so for this presentation, we are focusing on students with a disability. So throughout, keep that definition in mind for this presentation. The next definition that has come out through the WIOA is potentially eligible. And this is referring to any student with a disability who is currently on an IEP or covered under a 504 plan, regardless of whether the student has applied for or been determined eligible for IVRS. And these potentially eligible students can participate in PETS activities or those pre-employment transition services, which is the definition that we will talk about next. So for pre-employment transition services, otherwise known as PETS, these are collaborative services that create a continuum of VR and LEA services for students with disabilities. So PETS is broken up into 3 different areas for VR. It's required activities, authorized activities, and coordinated activities. We'll get into the definitions kind of on the next page for those, but these services overall are designed to provide services in the early stages of the transition process. And so PETS, the required activities that I had just mentioned, these are really the individualized services that you'll hear a lot throughout the schools and the AEA. And these are the 5 different areas: the job exploration counseling, the work-based learning experiences, counseling on opportunities, workplace readiness training, and self-advocacy instruction. So for job exploration counseling, this would include any counseling to assist the student with the disability to learn and understand, the demands of the workforce, types of jobs that are available, etc. For work-based learning experiences, this would include in-school or after-school opportunities or experiences that are outside of the traditional school setting that will be provided in an integrated environment. Examples of a work-based learning experience would include internships. Counseling on opportunities. This includes counseling on how to enroll in comprehensive transition or post-secondary educational programs at institutions of higher learning. Workplace readiness training is designed to develop social skills and independent living skills in order to demonstrate work ethic, attitudes, and behaviors for a competitive integrated employment environment. And self-advocacy instruction. This would involve training or instruction and counseling on self-advocacy skills. So the next slide is talking about the authorized and the coordinated activities. And this is just referring to the consultation services that are provided. This is kind of the behind the scenes or the systems change that VR staff are assisting with. For LEA staff and AEA staff or CRPs that might be listening, this is just kind of the broad overview. An example of this would be attending IEP meetings. The ones that you guys are going to probably be most interested in and hear most about within the schools will be those required activities. So if you guys have additional questions about authorized activities or coordinated activities during your local team planning meetings, VR staff can certainly explain those further. But again, those are kind of the behind the scenes that are supposed to be utilized to improve the transition of the students in kind of the system building activities. So the implementation of PETS. We are not here today to kind of have this magic plan set out for you guys. Obviously, WIOA is new for everyone, and everyone locally, the local teams are the ones that should be meeting to develop the plans on how to implement PETS. So as you guys are meeting, these are examples that are listed here on the slide. Of how to implement PETS in the area. This is really a collaborative effort between all the partners, including VR, the LEA staff, AEA staff, CRPs. VR staff, what our goal is here is not to supplant any services that are being provided by the school district, but it's to enhance their services. A good example that I heard that was happening across the state, we had a counselor go into a high school and review the curriculum, kind of talk about the different classes and things that they had to offer. They do offer a career exploration type class where they go through interviewing skills. The missing component with the class that was being offered was there was really no community connection, and so the VR counselor actually assisted with lining up businesses to come into the school, and some of the students did go out to the businesses and actually have practice interviews or mock interviews and train in that area. And in that respect, that enhanced the activity, and so that was a good effort of collaboration on both the school and the VR's part for that example of implementing PETS. But again, this is the local team should be meeting. So some of you may have had fall meetings already where you've started these discussions. After this webinar, you may continue to have questions or want to have additional meetings so that you guys can sit down and go over the information in depth, and VR staff would have that information to be able to do that with you guys to hopefully come up with a plan on how to implement this within your school district. So what do intensive services look like? We've talked about the pre-employment transition services and being able to offer those to the potentially eligible. So ideally, what the process kind of looks like now are as students are being connected to VR, not necessarily opening up a case file, but participating in PETS. They don't actually have a case file opened yet, but they are participating in those pre-employment transition services. Through those activities, students are going to be identified as to if they're going to need intensive services. And this is going to be based on the student's disability and what needs to happen in order for them to be successful. If the individual requires the expertise of the VR counselor to develop a job goal, create a plan, and then have those specialized and individualized services to be successful, those would be the students that would then proceed to open up a case file with VR and proceed on with our process of what you guys would be aware of, which is determining eligibility and going through that. We do want to keep in mind that if a case file is opened and a student's determined eligible, students aren't grandfathered in as in they're participating in PETS as a potentially eligible student, it would be the date that they actually applied for services would be their on the waiting list date. So we just want to keep that in mind. A student could be participating as potentially eligible with PET starting freshman year, but maybe they don't apply until junior year. We're not going to backdate all the way to freshman year for their application and the waiting list date. It would be when they actually completed and were identified as needing intensive services, they apply for services, and then that would be their application date to utilize for the waiting list. And so I'll hand it off to Brandy now to cover the Section 511 information.
Okay, Section 511 is a new portion of the Rehabilitation Act that was reauthorized under WIOA, and it's unique from the other portions of the legislation in that it does not go into effect until July of 2016. What Section 11 does is it enforces limitations on employers that hold special wage certificates, and the employers that the legislation are referring to are community rehabilitation providers, or CRPs. And the certificates that the CRPs hold allow them to pay individuals with disabilities below the minimum wage if that disability impacts the work that is being performed. According to the legislation, there are several specific conditions that must be met before CRPs can either, one, hire youth or students with disabilities, and two, before the CRP can continue to employ individuals with disabilities of any age at that sub-minimum wage level. So prior to beginning the sub-minimum wage employment, the youth has to have been provided documentation indicating completion of the following 3 activities. The first one is that they have to have received the pre-employment transition services, or PETS, that Mary had described. So that is the first activity. The second one is that they have to have applied for IVRS services and either been determined ineligible, or they had to have applied for IVRS services, been found eligible, and have obtained or developed with their IVRS counselor an individualized plan for employment, or an IPE. And then after a reasonable amount of time, all efforts to work towards the specific employment goal listed in the IPE are unsuccessful, and therefore the case file with IVRS has been closed. So that's the second of the 3 activities. And the third one is that the youth has to have been provided career counseling and information and referral that helps them to facilitate independent decision making as well as informed choice, so that they can continue to work towards that goal of competitive integrated employment. So once all 3 of those conditions are met, the youth can then be considered for sub-minimum wage level employment. And the purpose of the conditions is the idea of employment first, or that everyone, when given the appropriate supports, should have the opportunity to work towards competitive employment in the community, and that employment should be the first and not the last option. The other intention with legislation here is that the youth will be connected with folk rehab and aware of IVRS employment services prior to going into this type of setting. And I just wanted to also let you know that I recognize that these conditions that we talked about are not listed on the PowerPoint slide, but due to the length, it was difficult to get all of those on there. They will be available in the FAQ once that goes out. Okay, so once a youth is employed by a CRP at the sub-minimum wage level, Voc Rehab will then be providing them with information and referral, as well as career counseling, that once again helps them to facilitate that independent decision making and informed choice, and assist them to achieve the or work towards competitive integrated employment. They also have to be informed by the CRP of self-advocacy, self-determination, and peer mentoring opportunities that are not provided by that CRP. And in the first year, this process has to occur at least every 6 months, and then it's an annual requirement for 2 years or longer if requested by the individual or their guardian. So what does that mean for the schools? With regards to the schools, Section 511 of the legislation prohibits state and local educational agencies from entering into contracts or agreements with CRPs for students to transition into these segregated programs at that sub-minimum wage level. If schools are currently contracting with CRPs holding those special certificates, for the purpose of operating programs to employ youth at the sub-minimum wage level, then they will want to refrain from this. And it's best to start phasing that out now, as these contracts can no longer occur as of July 2016. The schools and Voc Rehab can continue to utilize CRPs to provide services in integrated settings within the community, and an example of that would be supported employment, but once again, that would be individualized in a team decision as to what services would be utilized. And the Memorandum of Agreement that will be shared next is going to specify how the DE and IVRS will cover the costs of those services. As Voc Rehab is going to have a much larger role in the process of decisions regarding sub-minimum wage employment, Voc Rehab is going to really want to coordinate with school officials on any referrals to extended evaluation or sheltered employment settings. And this is not only because it's emphasized in the legislation, but also it's going to be critical since most likely Voc Rehab has not been involved with these students in the past. And so, like Mary had said previously, it really is a new process and a new system for Voc Rehab as well as the schools. So those local teams consisting of the LEAs, AEAs, and IVRS staff, as well as any other key members of the team, are going to really want to get together and assure that they start to have conversations now about the process and how they want this to look and to work in the local schools. And before we get into the timeline, just an FYI on the copy of the PowerPoint that you may have received, the slide previously indicated that students that are already in the sub-minimum wage level of employment prior to July 2016 would be considered grandfathered in once 511 goes into effect. We did remove this as there's currently discussion regarding whether or not we will need to provide those 3 conditions to those youth as well. So until we know that for sure, we are not wanting to consider any youth grandfathered in. So if this is on your slide, please disregard it until further information is provided. But moving into the timeline, as stated previously, the changes for specific to Section 511 go into effect as of July 2016. And prior to that time, Voc Rehab is really going to be focusing on providing PETS activities, as well as that idea of employment first before a CRP placement in a sheltered type of setting. And there's nothing that prevents us, nor should we refrain from pursuing competitive integrated employment first with all of our students now. And that's always the goal, regardless of when Section 511 goes into place. And I also wanted to mention that the legislation specifies that while Voc Rehab is tasked with reviewing the process that we've discussed, our role is not to police CRPs or the schools or to enforce it. We are there to continue to work with our partners to move towards the implementation of 511 and to ensure this process is as smooth as possible. However, our goal is not to be the police of that process. And once again, in regards to the timeline, as regulations come out, we will inform the schools and our other partners if anything changes. We're hoping to have regulations by the spring. Once this occurs, we'll be able to provide more IVRS-specific policy information to you at that time. And with that, I'm going to turn it back over to Kim for discussion on the Memorandum of Agreement between DE and IVRS.
Thanks, Brandy. Okay, so I'm going to talk to you just a little bit about the purpose of the MOA, or the Memorandum of Agreement. The reason that we did that is it defines the responsibilities of both divisions within a tiered system of support. It provides for efficient and effective utilization of agencies' resources. One of the major components is to minimize duplication, and then finally to delineate a basis for continuous effective working relationships between the 2 agencies. The next 2 slides, Mary and I are going to kind of bounce back and forth talking about the IVRS component, because the bullet points on the right-hand side or the DE side kind of mirror what goes, so it makes a little more sense for us to go back and forth rather than one person to speak to the whole thing. So.
Sure. So the first bulleted item under VR, provide pre-employment transition services in collaboration and coordination with the LEA, ensuring that services, including individualized services under an IPE, are not duplicative, nor do they supplant existing LEA services. The supplanting issue, that's nothing new for VR. That's something in previous MOAs that we've always had written in there. We've just incorporated in the PETS activities that we need to make sure that when we're implementing those, like we discussed, that you're having those conversations, that you're talking about that with LEAs and AEAs, so that we're not supplanting any services, but are enhancing those services within the school districts.
Okay, on the DE side, our job is to ensure that AEAs and LEAs understand their responsibilities, and those include providing all existing educational assessment and performance information relevant for the determination of IVRS eligibility and services. So it's going to be incumbent upon the AEAs and LEAs to share that information back with your IVRS counselors so they don't have to duplicate assessments and things like that to get the process moving.
And likewise, on the VR side, we use that assessment information provided by education to determine eligibility and services, securing additional assessment only when necessary and assuming financial responsibility for the cost of the additional information. So essentially, we need to make sure that we're first utilizing any existing information that is out there. So as the AEAs and the LEA staff are providing us that information, we're utilizing that for eligibility. And then if beyond that, any additional assessments were needed after that information is reviewed, VR would be assuming the cost for those additional assessments that might be needed.
And on the DE side, we can request consultation and technical assistance from IVRS counselors when it's needed to plan and implement transition services.
And then likewise for VR, we provide consultation and technical assistance to the schools or educators as needed.
Okay, and on the DE side, we consult with IVRS staff for identification of students' vocational needs and services.
And on VR side, participate in the development of the employment plan and related components of the IEP based on individual need.
On the DE side, we're going to develop and complete the employment component of the IEP based on that individual need.
And maybe we should explain here, we had a question at a previous webinar on what the IEP versus the IPE was. And the IPE is Individualized Plan for Employment, in case you're not aware. And the IEP, Kim?
Individualized Individualized Education Program, excuse me.
Okay, so on the VR side, getting back to our column, the last bulleted item on this slide says develop an IPE for students within 90 days of being removed from the waiting list unless an extension is approved. This isn't anything that's too extremely new, I guess. We started this back in 2014 of going back to the 90 days of writing the plan. So we just have this written in at this point to show that it does have to occur within that 90-day time period.
And on the DE side, we want to make sure that our IEP employment goals are consistent with the IPE employment goals. We don't want to have an IEP read that the student wants to be a pro athlete and the IPE goal says that they want to work in a grocery store. We wouldn't be able to figure out the services that would make that work. So we want to make sure that we're having those conversations to make sure that they are close to being the same.
And likewise, again, same with VR. We want to ensure that IPE goals are consistent with IEP goals, employment goals. So we want to make sure that those services are aligning and those goals are aligning, as Kim just explained.
Okay, and then we are going to work from the DE side, work with the IVRS staff to ensure that a referral is appropriate and that the supports needed to complete the application are in place.
And for VR, provide or arrange for services required by the IPE goal when the individual has been determined eligible for IVRS services and has an individual employment plan where the services are needed for the student's specific employment outcome. This is nothing new. This is something that's carried over from our older MOAs that we've been operating under for as long as I can remember.
Okay. And on the DE side, it is our responsibility at the AEA or LEA level to pay for all services listed on the IEP unless another agency or entity has agreed to provide such services. And that could be with an agreement within your district or things like that.
The next bulleted item for VR is provide assistance in the purchase of tools, supplies, and other job-related personal expenses for IVRS eligible students who have demonstrated success in a 4+ career and technical program as it relates to the IPE goal. So for example, let's say that after the first year of the student, they've shown success in their program, in the 4+ program, and they're in need of additional tools. And these would be tools that they would be utilizing on the job after they've successfully completed their program and have been placed in employment. Then VR can actually assist with purchasing these items. Now for VR staff, we have to keep in mind that you do have to complete the R406 for these cases, and just for those of you who aren't aware, our R406 is our financial inventory. So all of our guidelines for completing that do apply in this situation.
And along with that, from the DE side, and this is not included on the slide, but if there's a discrepancy between the cost and what VR is willing to pay for things like tools and things like that, and the actual cost, so there's a difference between those two things, that cost has to be picked up by the school district, not by the student, not by their family, because that student still is a student of the high school. And finally, we are going to provide and or pay for extended school year supports as they are needed.
Yep.
And I'm sorry, I skipped one. We're going to provide and or pay for job coaching when it's needed as part of the instructional component of the IEP.
And so on BR side, the one that goes along with that one, arrange and pay for job development needed to serve the most significantly disabled students who require supported employment services. If long-term supports are needed after high school, IVRS will assist the LEA in coordinating these services. So for those students, the same guidelines apply for supported employment services. They have to be most significantly disabled. For VR staff, that's category 2, and they have to show the need that they actually need supported employment services. So if that's the case, then when it breaks down, the job development portion would be paid by VR, and the job coaching, as long as, again, the team has made that decision that these are the services that are necessary for this student, the job coaching would be covered by the school district.
That is the end of our presentation right now, and as we said, that's pretty much WIOA as we know it today. We apologize for the fact that it's a very dry presentation, but we could not come up with a way to make it fun and interactive. So with that being said, we'd like to thank you all for your time. We will leave the chat box open for about 15 minutes. So if you have some conversations with the folks in the room that you are listening in with, if you guys come up with some additional questions, please do put those in the chat box. And as I said before, we will post a copy of a recorded webinar and those FAQs probably right after the holidays, or as soon as we can get them done. So thank you so much for your time, and we hope that this has given you at least some basic information related to WIOA. Thanks a lot, and happy holidays.